and to thank the organizers, as well as to thank my boss, the administrator of the National Judicial Institute, Honorable Justice Salisu Garba Abdullahi, for allowing me to be here in representative capacity and also to share our own few thoughts on this very important topic and at this very important occasion. I've attempted to, in trying to stand in for my Lord, produce a small write-up which I have shared, but in order to catch up with the time, I'm going to be discussing based on a PowerPoint slide, which is here. It's just to guide me so that we can have an incisive discussion. Now, the topic to which we have been asked to talk or to discuss is on acceptability of forensic evidence in Nigerian courts. If you permit me, we would have loved to use the word admissibility because that's the word that is legally known and used. Although where acceptability, admissibility, if you look at the synonyms, they all go together. But be that as may, if you permit me, I would like to proceed. First, can we have the next slide? I have endeavored to put this through a sequence. And the first of the sequence is to look at the introduction, then we look at the types of forensic evidence that we may find, then the judicial case study, or some of the cases that are available of recent that touches on this. Then we're looking at the legal framework, because for us in the legal profession, things don't just happen. There is a framework to which you refer to provide the enabling background to support what is out there. Then we'll look at the challenges briefly. What are the available challenges that inhibit the application of forensic evidence? And then, of course, we'll conclude. Now, in the introduction, next slide, I've tried to explain that forensic evidence as a tool for justice administration derives its features and dates back to forensic science, because the word forensic itself bears the scientific methodology and scientific study. It is from the scientific application of scientific knowledge and ideas that we have basis for picking the things that are used or will be used as evidence, whether in court or for financial matters. I've also tried to explain in the introduction that forensic evidence and forensic science as is applicable, as is known in its modern form, actually derive or dates back to the 6th century with the Chinese. In the first paper I heard about the Romans, but I think historically those of the Chinese dates earlier. Then its application to the justice system arose as a result of the various changes and developments that have emanated from both chemistry and medicine. Then I'm trying to give that background because we're talking about evidence. But evidence, as we'll find the definition of what is evidence, is what is used as proof of facts. That's a simple definition of evidence. But then when you apply it, if you don't link it to science, then it will just be standing on its own. It won't make much sense, because some of the features and the tools and the ideas that are derived in developing or presenting evidence for admissibility purposes in the court are scientifically based. That is, we have to apply the scientific method to get these pieces and then present them either for purpose of criminal proceedings or justice proceedings, or lately, as we may find, that the accountants and financial actors and the rest have begun to apply some of these techniques to detect fraud, detect profit margins, detect tax evasions, and things like that in the financial field, or inclusive of criminal conduct. Then, like I've explained, today, other professionals like accountants and auditors have begun to apply these ideas and practices to detect profit margins, fraud, tax evasion, and other practices of individual and corporate organizations. The investigation, presentation, interpretation, and analysis of scientific information by a forensic scientist or a specialist as an expert witness in the court of law is therefore important to justice process and system, as it enables facts to be quickly and efficiently established with exactitude. That is, time passed, we use examples of police investigators and investigators generally. There's a heavy reliance on confessional statements and witness statements of those who have seen what had happened. But as you can find, there's memory loss, memory lapses, and even death of witnesses. So in the absence of these persons, if you rely so much on confessional statements, which using the same forensics or forensic science, it shows, or forensic psychology will tell you that most of the ideas generated from confessional statements are false. About 95% are not correct. And that is why in the court, there's a struggle for admissibility of confessional statements. So the best method of getting evidence is what? Forensics, the use of forensics. So forensic evidence will provide with exactitude. Let's use the example of DNA, deoxyribonucleic acid test or analysis. Once it's done, it pinpoints, right? Using the ribosomes and the rest, well, I'm not much of a scientist, but at least I remember my little biology and chemistry, would detect that, yes, there's no other person. Or even if we use fingerprints, as we mentioned, the holes and the loops on the human finger that is not identical to any other person in the world, we show that, yes, no other person. And that is exactitude to proof, linking with what the law provides in one of the forms of evidential proof that is known as proof beyond reasonable doubt. When you have exactitude, you have proved your case beyond reasonable doubt. Now it is now left for the defendant to show, okay, this is showing that the fingerprint here is showing that no other person but yours. It has been crossed, it has matched. So the body now a little bit shifts to you to begin to show that no, it is not you, and that becomes difficult, and that gives us the exactitude we're talking about in this respect. Now, next slide, please. I'm told I don't have time. I have 30 minutes. Now, in the light of what I have said, this paper discusses forensic evidence by reference to forensic science, by which evidence is collated for the purpose of legal proceedings. It identifies the legal framework on the admissibility of forensic evidence, as well as various ways and challenges to collation and acceptability. The paper concludes by recommending ways by which the use of forensics can be identified as a tool for reduction of fraud by financial institutions and speedy conclusion of cases by courts and other institutions. Yes, this reminds me that I need to explain also that with the exactitude that I've mentioned, if both parties present their cases using forensic evidence or forensic science as the background, I don't think there's much need for protracted delays or proceedings in the court. The prosecutor, for instance, presents his case with exactitude using this scientific basis and with the expert information or evidence that is presented before the court. There's nothing much to be done, but to conclude the case, there's no need for any adjournment. What are you adjourning for? Evidence has already been presented by this side. You have cross-examined. It has been accepted. Nothing more is left for the court to do, but to conclude. If any of us had watched the matter of the case between George Floyd, is it George Floyd, the policeman that had the problem with George Floyd, that he died? How long it took for the case to be concluded? With all the problems of witnesses, forensics, and the rest, getting all 3 months. 3 months. Why? Because of the use of forensic evidence, especially digital forensics. Okay, now let's look at the types. Most of these things, like I said, I don't claim to be an expert in this area, but within the short frame of time as a person in research, I had no choice but to read, go to a library, look at even my university notes in those days, and then I was able to identify some of these. I'm sure the experts here, you know. Now, we talk about, I already defined what is forensic evidence, isn't it? The application of scientific knowledge or ideas to solution of problems or crimes, either through the use of investigation, for presentation of evidence in court, so that cases will be concluded. That's my definition. Then, the nature and types, we will find digital forensics. I know that in the past 6 or 7 years, they have been having training with the United Nations Office on Drugs and Crime. This has featured prominently with the judges and those who have been training digital forensics. The use of electronic tools, computers, and other communication technologies for purposes of admissibility in court. And for those who are involved in terrorism trials or investigation, you will discover that this is heightened. Your phones are one, the masks that are out there, even with the smudges that are cast on your phones. In those trainings, I was able to even learn that even without your phones, if you like destroy the phones, all you just need to do is the last call that was made. Even me as a layman, I was taught and I was able to even apply, go to the nearest mast and identify the last mast that this is linked to find out. So some of these things are out there that are very important for use. Then you have fingerprint analysis, DNA, handwriting, ballistic, use of guns and weapons that are fired. In those days in school, we talk about, is it the toke or so, that when a gun is shot, the person who shot, in between the fingers, what is known as a toke, the return creates some things on the person's hand. So if you detect early, you're able to trace this. Then you have blood spatter analysis in terms of identifying the blood of the victim to the criminal defendant. There's a case here, Shonubi against Shonubi, which did really apply in 2015 that I've used as a case analysis. Then forensic pathology, the identification of the dead, the cadaver, to see what really killed this person. And this is used mostly in identifying causes of death. Then forensic photography, forensic toxicology, that's the use of drugs and drinks and liquids and their effects, whether what this has brought about. Then forensic odontology, the use of the tooth. This is interesting to me because the bones or the teeth are actually the last thing to follow from, I think, the human person, right? Or you can actually use the teeth of a person to date. First of all, we are taught in biology, basic biology, that an average human being has, is it 32 tooth in his mouth, right? So if you check and find that this person is yet to have the full complement of the tooth, it tells you that he's yet to be a person of age. Or if some have removed, maybe the molars or the premolars, as we have them, or the canines are removed, which of them are used in biting, which of them are used in crushing. It gives you a lead into something. Then forensic psychology, which is the study of human behavior, especially in relation to his attitudes, character, personality, and then the application of, in terms of the forensic aspect of it, I'm interested especially in, I think section 268 of the Administration of Criminal Justice Act, which talks in terms of identifying whether a person is capable of standing trial, or even after standing trial, there's a defense to which this person is bringing up of insanity. And the court is mandated right from the beginning, but most times these provisions are not used in the court, and is actually very good for us to advert our minds. Before the person stands trial, the psychological build-up of personality of this person is ought to have been measured to show that this person is responsible. Because the law provides two grounds of responsibility. First, it makes all of us to be responsible for our conduct, except 2 or 3 circumstances. One, either due to insanity or infancy. Now, how do we get this without the use of forensic knowledge or forensic evidence or forensic science, how do you get to a person's mind to know that, oh, this person was a semi-mad person or had some issues or was still a child? You can look at a full-grown person today and apportion some age to the person, but that is not true, except you use some scientific method, either through is it MRA, magnetic resonance imaging, or DNA, or some other form, carbon dating and the rest, that you're able to do. These are scientific methods, isn't it? And then also it's interesting to note that under the Child Rights Act, where the paternity of a person is in doubt, the court is enjoined to apply forensics or to call for forensic evidence. Now we can see that these tools are out there. Now the problem is used. Then forensic entomology. And then the host of others. Next slide, please. Then, without waste of time, I'm sure most of these things are there with the paper with us. We can actually read them up. I want to look at the case study. Now, the case study is, there are many cases actually, but I'm particularly interested in this one because it's a little bit of the most recent, 2015. When we say most recent, it's not as if it is yesterday or today. But if you can't find anyone that is most up to date, then at least you can say this is most recent. Now, the case of Shonobu against people of Lagos State, if you permit me, I'll read. The case itself illustrates the attitude of the court to the use of forensic evidence or admissibility, or if we use the word that we have been asked to use, acceptability of forensic evidence in courts in Nigeria. The appellant was arraigned before the High Court of Lagos State for the offense of murder. She was alleged to have killed Mrs. Sten by strangulation in her bathtub full of water when the body of the deceased was discovered by her mother, Wilma Sten, and her friend, who returned together from a shopping spree, raised an alarm which attracted security men and police attached to the Shell Nigeria Exploration Company who were around. The environment was thereafter cordoned and 9 suspects were arrested. Now, based on forensic analysis carried out both in the United Kingdom and in Nigeria, only the appellant was arraigned. You see, I was talking about exactitude. He was found guilty by the trial judge based on scientific evidence, surrounding circumstances, and evidence of prosecution witnesses, and sentenced to death by hanging, pursuant to Section 316 of the Criminal Code Law of Lagos State, Cap C-17, Volume 12, 2003. The convicted person was aggrieved, and he lodged an appeal to the Court of Appeal. But the appeal was dismissed, and the court held as follows. Forensic report of PW6, Exhibit E, was tendered. He stated that of the 3 questions in forensic analysis, 2 questions were answered in Nigeria, while the final question was sent to London. He said there was a stain on the shirt of the defendant, subjected to 3 stages of test based on the following questions. 1. Was the stain blood? 2. Does this blood belong to a human being? 3. Does the human blood belong to the deceased? And it was this question 1 and 2 that were answered in Nigeria, and that the answer sent confirmed that the stain on the shirt was blood, which matched that of the deceased. He further added that the evidence of the PW6 to the effect that the DNA analysis of the blood stain found on the checkered shirt of the appellant matched that of the appellant, and was positive identification of the appellant's culpability as the person that caused the death of the deceased. So you can find that in this case analysis, as an example, there are many others. The use of forensic evidence and forensic science to get the precise evidence that was required for the conviction. Next slide. Now, I'm going to look at the overview of the available provisions in the laws. Now, you will find that there's no specific law or legislation or statute, as the case may be, that says and provides the practice notes, guidelines, and procedures on the use of forensic evidence in Nigeria. None. I have not been able to find any. Now, what you'll find is that dating back to the old Evidence Act of, I think, 1958, which was itself based on Sir John Stevens' Digest of Evidence, only had some tangential relationship with forensic evidence, especially in what was known as expert evidence. Now, but there's no specific provisions and say this is how you do, this is how you do, like you find in some of these institutions, and we have specific laws or this related to it, on how the police or investigators may apply in the various steps they need to take, the protective measures, the packaging measures, the collation, and the procedures of ensuring that what they are bringing is correct, is genuine, and the conclusions are reached fairly without any other motives. Now, that was the situation prior to the 2011 Evidence Act. Even now, with the current Evidence Act, there is no direct provision that has reproduced or have gone so different from the old one. But now, at least we have some copious provisions that enables the application of forensic evidence, especially in what is known as the digital evidence. Now, the key provisions, I was able to find 16 key provisions in the Evidence Act. And in the paper that I have distributed, I have reproduced those provisions, starting with Section 1, which talks about application or admissibility of evidence. Then, like that, till you get to Section 258. And without boring you, if you have the paper, you can check or cross-check those sections to see. Now, also you'll find in the Administration of Criminal Justice Act, which section I've tried, some of the sections I've tried to explain. There was an omission of one of the sections there. So by the course of going through the paper again, I was able to get it. The one that talks about insanity, that if the court finds that the person will be unable to stand trial, that to ensure that this person understands the nature of the trial and what trial proceedings, that the court will order for examination of the person. That's a forensic reference. That once is referred to the persons who are supposed to take care of such things, and then the report is brought back, you stand his trial. And also, even when the person is in custody during his bail, for application of his bail, sometimes people will feign illness or sickness. If you remember the Hebrew case, while they are in detention, they start feigning sickness. While they were out there, no problem. But as soon as they are arrested and charged for an offense, they become sick persons. They have I have hypertension, I have prostate cancer, I have all this. So how will the prosecution or investigators respond to this? You have to refer back to forensic science, isn't it? By examining the person and presenting evidence to court that, look, this man is hale and hearty, he has no problems. So those sections are there. I think section 112, 112.1a, sorry, it's not B. And then 161.2b provides for those type of events. And these are the provisions that investigators can actually readily refer to in trying to generate this evidence that will be presented before the court. Now, next slide. Now, before the challenges, I want to look at the word itself, acceptability or admissibility. What are the grounds for admissibility or acceptability before the court? When you generate all this scientific evidence and you want to present before the court, presentation is a different thing. Acceptability is another thing. Now, acceptability in terms of admissibility has to follow some set guidelines. And these guidelines are what? That evidence must fit into what the Evidence Act itself or any other law providing for evidence provides that such evidence in such form will be admitted. For instance, if you look at Section 84, which is on digital evidence, computer-generated evidence, Section 84 for 1 to 5, and then Section 258 that defines what computer itself is as part of documents. Those documents have to fit in to circumstances in terms of certification, but now there's even an authority that talks about certification must not be in such a way that you must produce a certificate. Once the user, the person who was able to produce that electronic evidence or that digital evidence is able to come to court and say, look, I've been the one using this computer, so period to so period, I have used it, and for so period there has no problem, and this is the evidence that I was able to generate from it. That'll be okay. You don't need to go and start writing and present, except it is not the original person who used it, it's somebody else. Then that person would require to make that certificate. So I just needed to make that very clear. It's a recent authority of, I think, just last 2 weeks or so from the Supreme Court. That's what it says. So you don't need to go and start bringing certificate to write, oh no, I certified that I was the user of this thing, I produced this document from here, it has no problem, it has no difficulties. No. Because that will create difficulties. Now, we're looking at the challenges. Now, one of the challenges, like I've explained, there are no guidelines and templates, including legislation on methods and procedures for forensic evidence. What we use now is ad hoc, or those say staccato. I don't know whether the EFCC, whether you have the templates, you have guidelines, since you have some of the equipment with you. I'm sure you have some of the equipment. They may not be the most recent or up to date. And then you may not have guidelines on how your operatives will be able to apply and collect this information for the scientific purposes of admissibility in court. You need to develop guidelines and templates so that it won't be an all-comers affair. Because when you go to court and you present this, you're going to have cross-examinations. Then laboratories, tools, and equipment. As of the time of drawing this up, my attention was drawn, and I think I actually visited this place. I just came back from Lagos on Saturday. I was working with the UNODC in Lagos, so I decided to just pay a visit because some of the discussions we're discussing were on this. I think only 3 laboratories that exist in Nigeria in terms of maybe fingerprints and some of this, the ballistics and things like that. Only 3. And the equipment there are, if I show you the pictures, you'll weep. Because the UN group that are working on this with the judges and some of the investigators and prosecutors actually went there, they took pictures, did videos. If I show you those things, you weep. They are as old as Mongo Park. The computers, some of them are, I don't know whether the staff there are using it for games or things like, or they're just there, warming the cables. And then the place itself is so dusty, it doesn't look like actually a laboratory. And then the storage is very pathetic. So that's the problem. Then the tools and equipment, as the modern ones, are not there. I'm sure the ones that are there, as like I said, as far as old as Mongo Park himself. Then education and training is a problem. If you train, we don't have any school that is devoted to forensic training. None. I'm sure the training is ad hoc as well. And we are dependent on the foreigners and the foreign institutions where we pay in a lot of money to travel and go there with all the attendant risks. Then funding is a challenge. Most of the funding are devoted to other things. And we find that this one is not much of a headache that we shouldn't be worrying ourselves, so the funding there will be very little and minimal. So these are challenges. And then the understanding of the criminal justice institutions, or let me say justice institutions, as to the use of forensic evidence itself is something else. The mind and attitude to, we have not been doing this now. What do you need to waste our time with this machine now? Let's do the way we have been doing. You have somebody whom you have arrested. Lock him up for 3 days now. Don't give him food. Next day, he'll get tired. He'll tell us what he has done. We'll find those ones as easier things rather than reliance on forensics. There's a training I was doing for Council of Europe one time, and on ways of perhaps looking at this, and then the escape routes by which investigators will balance, not escape routes now, but will balance human rights and balance criminal justice and law enforcement. And this was one of the issues. Now, the whole world is turning to forensic evidence, especially digital, because on the streets, you find cameras, even the houses of individuals. You have cameras that can, at the click of a button, tells you who has committed an offense, where he left to, and things like that. And even with what do you call the maps or these other tools that you find today can be able to trace a person. We're not using them. You know, what is the measure? If we try to measure the level of use of these tools and instruments, you find that it's down there. So the solution, next slide, please. I think the solution is simple. If we resolve those challenges, we'll have the solution. So thank you very much. That's a little I can share with you. Thank you.
Thank you very much. That was a brilliant presentation and quite illuminating. When I saw the outline, I didn't see anything on solutions. So I was waiting to ask a question at the end. But he carefully said that answers to the challenges are the solutions. That's quite brilliant. But however, are there conscious efforts that are being made by either government or the courts and all that, institutions to provide equipment? You know, the office you talked about, the archaic equipment. Is there any effort to update them and all that so that we can have a better justice system? Thank you very much.
I think the response will be the responsibility of the various law enforcement agencies. Each law enforcement agency. Let's start with the police, because the police under the Police Act of 2020 has actually been, or even prior to that time, has been given general powers of investigation. They have wider reach as well. There are places that ordinarily you may not find any other government station but you have a police station or a police outpost. That tells you that law enforcement is pervasive. So it is for them to use, if you use about just 2% of their budget, you don't think they could be able to provide this? Just 2%, yes. 2% of police budget, yes. What is 2%? 2% of, let's say, 300 million. 2% of 300 million is what? 2 divided by 3 times 100. 6 million, right? Good. 6 million times 8 years. Let's say from 2015 to date, if every year you were providing one. No, I don't want to go to extremes. I just want to use the simplest. Oh, no. This is Nigeria, and this is where we live, and this is where the problems are, and we're trying to find the solutions. Do you understand? So we keep saying, no, this is Nigeria. As if Nigeria is a place that's made up of flowers and the birds in the air, or only air. No, it's human beings. So human beings cause these problems, human beings will solve these problems. And these human beings are who? Nigerians. The budget that are provided for police, are provided for EFC, provided for DSS and the rest, is not budget of Ghanaian police or Ghanaian EFCC in Nigeria. Use 2%. Every year, just put 2%. Okay, if 2% is too much, 1%. For 8 years, you have those equipment. And I want to say, because we have had this engagement with the UN group, and we know what is there. It's not much, it doesn't cost much, and some of these institutions are willing to assist. Even when they provide, let me tell you, sorry, you know, this is Chatham House. Even when some of these equipments are brought as like test pilots for us, we abandon them and go and try to say, we can give our own contracts and get our own. And then very well, we don't even use them again. It's not good. Do you understand? We need to be genuine. We need to tackle these things. Those problems. Now that we have terrorism, kidnapping, banditry, is it Ghanaians that are affecting? Is it Sudanese? Is it Americans? It's us. So if we don't solve it, it will still be there. So for me, I'm advocate of not so much, just one. The amount of money that people steal in their various offices. I said, no, just don't leave 1%. If you steal the rest, but leave 1% so that we can do these things. It's as simple as this. Let's be frank to ourselves. Do you understand? That's the way I look at it. So the response is each institution, look at yourself, try and solve it. Your main job, the main task of the police is investigation, crime prevention, right? Crime detection. Is it your hands that you're going to detect? Or is it your eyes? You're relying on witness testimony that they will lie to you. I know in those days, police have people around that they pay some money for information, but they lie now because they need that money. Or, you understand? And so you need to rely on forensics. Forensics will not lie. If you test my blood and say, look, like for me, I'm O negative. And then it cross matches what you have found. What else? It's just only, you even tell the judge that this man is just denying. I was at a training last week that they were telling the judges two things that the judges ought to be looking at from now, they ought to be looking for. If this man has committed an offense, what is the law that is before you? Ensure that he convicts him. Let him not escape. But if you're not sure, or even if you're sure that he has committed an offense, make sure you find the law. Whether the prosecutor has not brought it or not, or you find a way to direct him so that the man will not escape because we're having too many criminals in society. Then on the other side, if he has not committed any offense, by all means, even if there's no law before you, try and let them address you and find it so he will go free, so that he will not go and join the criminals. Because once he goes into prison and correction, he becomes a criminal. So that's my response to that, sir. Thank you.